For the third time, the Illinois Supreme Court has thrown out a law that would limit malpractice awards to people who sue their doctors. The state's top court said that a Blagojevich-era statute that limits amounts that juries could award for pain and suffering is unconstitutional. ABC 7's Ravi Bajwal joins us from the newsroom to explain. Ravi?
Well, Linda, in this case, it is the Illinois Constitution that we're talking about, but the principle that the justices invoked was something that applies right across this land. That's the separation of powers. Illinois' top court found that a law created by the legislature took away the power of the judiciary, specifically juries, and that trumps whatever good reasons may have been behind creating a law that would cap non-economic losses for victims of medical malpractice in Illinois.
She's totally wheelchair-bound, always will be. She has cognitive deficits, cannot perform, speak, or do the things that a normal child her age can do. She is fed through a G-tube. She cannot even take food orally. That's the way she will live the rest of her life.
4-year-old Abigail LeBron's situation has been the test case for a group of challenges to Illinois Law 94-677, which ironically was passed around the time she was born. It caps damages for pain and suffering at $1 million for hospitals and half that for individual doctors. Her family is suing because they say her mother wasn't given an emergency cesarean section in a timely manner at Gottlieb Hospital when problems developed during birth.
Limiting her recovery to only $1.5 million would not provide any compensation for the fact that literally her life has been taken from her.
That figure would be beyond what a successful suit would get from defendants for what is called a life plan for a victim's care. But the Illinois Trial Lawyers Association says today's ruling won't stop insurance and healthcare companies from lobbying for new restrictions. Pete Flowers says what is needed to lower medical malpractice costs is insurance reform.
Frankly, the insurance reform allows the premiums to potentially be affected by more companies coming in, driving down the price, like we do on every other resource in this country. It's competition.
But Dr. Louis Blumenthal disagrees. The obstetrician-gynecologist was at the forefront of efforts to keep members of his specialty in Illinois after several reports said in the middle part of the last decade, doctors were fleeing Illinois due to malpractice insurance premiums that were well into the six figures.
If there are no physicians practicing medicine, our system is going to be in disarray, and physicians are worried that they're going to be practicing in a hostile environment.
He says after the 2005 caps were put in place, the shortage of specialists eased off. But those who are applauding today's ruling say what is at stake really has to be fixed at a higher level.
There is no doubt that the mega-billion-dollar healthcare industry is closely tied to the hip of the mega-billion-dollar insurance industry.
And late this afternoon, those industries are reacting. Gottlieb Hospital saying it's disappointed in today's ruling and that the, quote, current tort system is resulting in an inequitable distribution of health care resources. Now, the Illinois Hospital Association is saying that this decision will, quote, renew the malpractice lawsuit crisis. And Alan and Linda, we should point out that Abigail LeBron's case has not been decided by any jury just yet. Just that when it does get there, like all the others, there won't be a limit on compensation for pain and suffering. Reporting from the newsroom, Ravi Bajwal here.
Okay, Ravi, thank you.